Leland Gardner was a happy, healthy 6-year-old boy when he visited Cowabunga Bay Water Park in May 2015. Less than 30 minutes after this photo was taken, Leland's seemingly lifeless body was pulled out of the deep end of the park's wave pool. He was revived, but the damage was done. He suffered permanent, catastrophic brain injury and will need round-the-clock attention for the rest of his life. Attorneys for the Gardner family say the water park displayed a callous disregard for public safety because while state law required 17 lifeguards to be on duty at a turbulent water feature of this size, only 3 were on duty that day. The park's general manager admitted they'd never met the legal standard for lifeguard staffing. The I-Team learned that the health district had never bothered to inspect the park while it was open. Even after Leland's drowning incident, the park still did not assign 17 lifeguards to the wave pool. Plaintiffs' attorneys say it's too much to expect only 3 lifeguards to scan such a large, noisy, active environment.
Ordinarily, if there were a number of the lifeguards there, he would be concentrating on an area about like this, okay? Instead, he's concentrating on an area like this. That makes a big difference with respect to his perception.
Defense attorneys have argued the lifeguard who pulled Leland from the pool got to him within 15 seconds, but the Gardners say the brain damage indicates he was underwater for several minutes. Lawyers for Cowabunga Bay told the court the 6-year-old may have suffered a heart attack while swimming, and that there's no proof the lack of lifeguards had anything to do with the damages caused. They say this is a case that should never be heard by a jury.
Just seeing him, they're going to want to give him money. The average lay juror is dangerously likely to take one look at Leland Gardner, find out that he was injured at a water park, assume the water park is owned by a corporation, and just want to give money to that family.
Plaintiffs agree there are corporate owners and that the park was directed to cut staff because it was under financial pressure at the time. Leland had no history of heart trouble before or after, they argued, and said the lifeguard on duty wasn't legally certified but signed a false certification form after the drowning.
All of these facts demonstrate from day one a consistent pattern of denial, of deflection, and of deceit by the defendants in this action.